Hello there, this is John, and this is Chapter 3 Medical, Legal, and Ethical Issues. So, a couple of terms you should be aware of. The first one is scope of practice, and this is defined by your protocols, and it's basically what an EMT can do legally in, let's say, the county of San Diego or whatever county you might be working in. The other term is called standard of care, and this is kind of more of an ideal or kind of a gray area. So say, for instance, you're working as an EMT, you go on a call, and there's a 25-year-old female who's having an asthma attack. And you, for some reason or other, you do not provide her with oxygen. And because you didn't provide her with that medication, you've dropped below the minimum standard of care, and you could be found negligent in a court of law if she's harmed in some way by that lack of providing proper care. The other definition or the other term to define is called duty to act. And this means that when you are on duty, you are response ready. You are in uniform, you're mentally and physically able to respond. You've checked out all your equipment, you know everything is response ready, and you're prepared to render care to people. The question here really is when do you have a duty to act? And this varies from state to state. So in the state of California, it says that the only time you have a duty to act is when you're on duty. If you go to another state, like say Arizona, they have a different law, and it says any medical professional has an obligation to act on or off duty. So again, it's a state-to-state process. The only problem here is public perception. So if you somehow identify yourself as an EMT, whether it's verbally or non-verbally, I'm an EMT, or you have a tattoo or a t-shirt or a bumper sticker on your car, or whatever it might be, if you identify yourself as an EMT, even when you're off duty, the public has a perception that you're a medical professional and you have an obligation to respond or to act. So if you do somehow identify yourself as doctor, nurse, EMT, paramedic, firefighter, whatever it might be, and you decline to respond, don't be surprised you might hear back about that. So be careful about identifying yourself unless you really truly have a great desire to respond when you're off duty. So the Good Samaritan law has been around a long, long time. They were designed originally to protect physicians from rendering care, when they're not at work. The one thing it does not do, it does not protect you from being sued. So you could stop, render care to somebody, and as long as you stay within your scope of practice and you do whatever is best for the patient, even if they die, you could basically be found not guilty. The difference is, of course, you're still going to go to court, you're still going to need a lawyer, so you're still going to pay some lawyer fees. So it doesn't really totally help, I guess. A few more terms. So sovereign immunity. This was a situation where for years and years and years, any state, county, federal agency, police department, fire department, EMS, those types of things, they thought they had sovereign immunity. So if they did something really, really bad, and it was negligent, they figured they couldn't be sued. Well, this again varies from state to state, but in the state of California, no matter what agency, whether it's public or private, if you as an individual who has been harmed, if you can prove negligence, you can still take that agency, whether it's public or private, to court and sue them and win, because this sovereign immunity is not totally working very well anymore. Go figure. Statute of limitations, pretty straightforward. You did something bad 10 years ago, and now it's past the limit of prosecution. So now, of course, they can't touch you. Doesn't sound very nice, does it? Contributory negligence. So you have a gentleman who's crashed his car You arrive on scene, you find him standing by the side of his car, talking on his cell phone, holding his neck. He's calling his lawyer, go figure with this one. You render care to the patient, you transport him to the hospital, and he winds up being paralyzed from, let's say, the waist down. So he takes everyone to court, and he says, you were negligent. You didn't put him in proper spinal motion restriction. You didn't do this. You didn't do that. But what could contribute to the negligence was the fact that he got out of his car. He was walking around talking on a cell phone prior to arrival. So you could say, well, I might have done something wrong, but potentially if the patient had sat in his car and waited for us to arrive, he might not be paralyzed today. So it is partial contribution on both sides of this. So if you think about calls, if you go on some type of 911 call and you arrive on scene, you might see multiple people there. And really what it comes down to is we have to define like who's a patient here. So this is the definition of a patient, and this follows County of San Diego protocol. It's pretty straightforward. So the term chief complaint is usually why people call. The patient themselves might call, I have chest pain, I'm short of breath, I'm dizzy. Those are all chief complaints. Someone else might call for the patient. I found them unresponsive on the ground. Being unresponsive is a chief complaint. So you can kind of see. Now, there are times when you arrive on scene and the patient says, gosh, I'm fine. I have no problems. But because of what might have occurred prior to arrival or possibly what you saw upon your arrival, even though the patient's denying any pain or any type of complaint, you suspect they might be ill or injured. So now you should treat this person as a patient. Anytime someone is not completely oriented to person, place, time, and event, then they're automatically, for whatever reason, they're automatically patients, and they should be treated as patients. This could be due to drugs, alcohol, dementia. Let's say you have an Alzheimer's patient who escapes their private residence and they're running around the streets and they're always disoriented. That's just their baseline. But because they are disoriented and they only know maybe their name, they're automatically patients, and they would have to be assessed and transported to the hospital and be evaluated by a physician before they could be released back to whatever home they're living in. Someone walks up to you in the ambulance, you're sitting in an ambulance having lunch, and some guy knocks on the window and goes, hey, dude, I want to go to Mercy Hospital. It's Taco Tuesday, whatever. And anytime someone asks or requests transport or any type of treatment, you need to provide it. It's by law. So this person would automatically be a patient. For instance, you might be sitting in the fire station, there's a knock on the door, and some guy says, hey, I'm a diabetic. I ran out of test strips, and would you mind taking my blood sugar? Sure, why not? But he's a patient. He should be evaluated. He should be documented as a patient. Where it gets kind of complicated is with minors. Now, the definition of a minor is anyone who's obviously under 18 years of age, so 17 years of age or younger. There are things like emancipation of minors. I've never encountered one ever in my entire career, but I'm sure they're out there somewhere. But you have a child and they're not accompanied by a parent or legal guardian, and you believe they might be ill or injured, or they might appear to be ill or injured for one reason or another, they are automatically patients. Now, if for some reason they're not ill or injured, and I've been on these calls where I've got 3 or 4 or 5, 12, 13, 14-year-old kids, one's injured from a fall off a bicycle or a motorcycle, the rest of them are fine, but just because they're at scene, they basically are my patients. But because they're not ill or injured, they do not need to be transported to the hospital. So in this case, I would wind up having them call their parents, or some kind of, it could be an older sibling, it could be whatever it might be. It could be the principal at a school, the school nurse, whatever it might be. And I would provide what's called a transfer of custody to that parent or responsible adult. So once you've identified this person as a patient, you need to provide some kind of consent. So there's different kinds of consent applying to different situations. Most common when the patient is alert and oriented and is answering questions appropriately, you need to have them express to you that they're allowing you to touch them. So you say, "Hi, I'm John. I'm here to help you. Do you mind if I check your blood pressure?" And they either nod their head or they say, "Yes, go ahead." So they give you expressed consent, either verbally or non-verbally. Once you've done your assessment and you've come up with some type of differential diagnosis of what's going on with this patient, and you formulated some form of treatment pathway, you would inform them of that. I think you are having a dizzy spell because you're having a stroke. So what I'd like to do is I'd like to take your blood sugar, give you some oxygen, and transport you to a stroke center. What do you think? So you've informed them of your plan and they've agreed to that treatment. Remember, these people are awake, they're alert, and they're able to make their own medical decisions. Now, if they have some kind of altered mental status or altered loss of consciousness, or level of consciousness, if you want to call it that, if they're unconscious, they're confused, disoriented, or they are unaccompanied minors who you believe are sick or injured, it's by implied consent, meaning that this person could speak to me and understand what I'm saying, they would say, "Yes, please help me." Same thing with the minors. If the parents were there, they would say, "Yes, please help my children." Now, if there is a child who's sick or injured and the parents are there, uh, then the parents themselves would make that consent. So you would talk to them as if you were talking to the patient. "Hey, mom, hey, dad, what I'd like to do is I'd like to assess your son and then, treat his broken arm." And they say, "Yes, please go ahead." Another version of this is what's called involuntary consent. So this is someone who's in custody. So the police arrested somebody, and in the process of the arrest, the patient gets injured in some manner. Go figure with this. Or maybe you have a person who is normally disoriented and they're in some kind of conservatorship. So they actually are, they no longer have control of their life. Someone else controls everything that happens for them or to them. So at this point, when you have a patient who's in custody or in some type of conservatorship, you're going to be talking to the person who's in charge. So that you're going to be talking to the officer who's arrested the patient. You're going to be talking to the person who is in charge of the person in the conservatorship. They're going to speak for the patient. You're going to ask them the same questions. Is it okay if we assess your prisoner? And the cop will say, "Sure, yeah, go ahead." And then you'll come up with some kind of idea about treatment. You explain to the officer, "This is what we'd like to do," and the officer would say, "Yeah, go ahead and do it." So again, same kind of situation, just a little more complicated because of the custody issues. So when you have a patient who is completely oriented and they have what's called the capacity to understand their situation, what's happened today, and the also risks and complications of not going to the hospital, they are able to refuse transport and treatment, or both sometimes, depends on the circumstances. You must always make this patient fully aware of the consequences of them not going to the hospital. And you also need to state that this could lead to their death if they don't go. And you can also let them know that at any time they can recall 911 if they're feeling, worse or things are changing. There's two types of forms. They're actually the same form because now it's all online. It's all through the cloud and your iPad and stuff like that. But the first one is called against medical advice, and this is the strongest one. So this is someone who you really feel needs to go to the hospital based on your clinical their presentation and your clinical assessment. This is a high risk population. This is really old people, really young people, people with really bad long-term medical conditions, things like that. Abnormal vital signs, really high heart rate, really low heart rate, really super high or really low blood pressures, things like that. And any kind of serious illness that presents here and now, or any potential serious injury. These patients, they can refuse, but these are high risk AMAs. And this time you probably want to call the base hospital and talk directly to a physician to get their permission to do this, and maybe even have the doctor talk directly to the patient at scene over the radio to help maybe convince them to go. Now, if you have another patient who is one of the low risk populations, this is a young person, young healthy person, teens, well, not teens, I guess, but 20s, 30s. They cut their foot at the beach, they twisted their ankle, they broke their wrist, a minor injury, they don't feel well today, whatever it might be. The vital signs are totally stable. And it's the same form, but now this is an agreement between you and the patient. It says, I, John, EMT, agrees that the patient does not need to go to the hospital by ambulance today, and they'll seek their own medical care. And you both sign it, and it's released. Of course, you still have to document all this stuff anyway. And then, of course, you're going to release the patient at scene. Now, when it comes to AMAs and also releases, try at least 3 times to persuade the patient. And I even document that in my narrative in my patient care reports. Patient was offered a ride to the hospital 3 times. He declined each time. If there is someone at scene, a police officer, firefighter, neighbor, friend, family member, have them sign as a witness that the patient signed. Because all they're saying is that they witnessed the patient signing and agreeing to the AMA. Encourage the patient to seek help. And again, if they are feeling worse, their complications are getting worse, you can have them say, you can call 911 at any time. And it's really most important thing is for you to document. If you go through your documentation, your patient care report, make sure it's very clear and concise, covers all the key points, everything that you said to them, to make sure, because these are high liability calls for us. And if you're going to go to court, it's more than likely going to be because of an AMA that went wrong. So advanced directives. These are DNRs, do not resuscitate orders. There's a really basic form, which is the state of California provides, which a lot of agencies use copies of. And all it really covers is resuscitation issues. I'll show you a form of what it looks like here in a couple of seconds. The other type, which is more popular now, is called a POLST, and this is physician order of life-sustaining treatment. And it's a little more complicated for us because the patient, while they're still lucid and able to fill the form out and sign it, of course, they can decide what level of care they really want when they become incapacitated. Also, thrown into all this, sometimes patients have what's called a durable power of attorney. So when they're still lucid and able to make their own decisions, they're going to assign one person. It could be a family member, it could be a lawyer, it could be a neighbor, to make decisions for them when they do become incapacitated. So if the person goes unconscious, goes into cardiac arrest, the person who has this attorney in fact power would be speaking for the patient themselves. So DNR, basically, what it means is, in general, it says if you have no pulse and your breathing is ineffective or absent, you don't want anything. You no compressions, no ventilations, no defibrillation. If they have a pulse and they're still breathing effectively, we still treat them normally like any other patient. We give them pain control, we stop their bleeding, we feed them, we keep them warm and comfortable. The only time a DNR applies is, again, if their pulse is absent and or their breathing becomes ineffective. Now, you arrive on scene and this patient has no pulse, maybe they're not breathing, and if the document in whatever form is there is present and it's valid, it's signed and dated, and everything is correct, then honor it. That's what it's there for. If the DNR or pulse is questionable, absent, or the family themselves question it, the pulse might be there, the DNR might be there, but the family's not comfortable with it. The patient's in cardiac arrest, and the family goes, no, no, we want you to do everything. The safest thing to do legally is just start CPR. Start CPR on the patient by family request. Get on the radio, speak to the physician about it over the radio. More than likely, you'll transport the patient to the hospital and let the hospital deal with the situation. So this is your basic state of California DNR. Really simple. A lot of convalescent homes and hospitals take this exact same form and they put their own heading on the top. Same form, really, really simple. I, John, if I do anything, basically a sign, just let me die, whatever it might be. As long as it's properly filled out, it's signed and dated, it does not expire. The patient can tear it up if they want. They can write, void across it or whatever it might be. But until then, it's valid. The other form of this is called the pulsed. This one's a little more complicated for us because, again, the patient has the choice of saying, yes, I want everything, no, I want nothing, or somewhere in between. So this one you really have to read to make sure what boxes were checked. It still needs to be signed by a physician. It still needs to be signed by the patient themselves or their designated person that can sign for them. But read these carefully because, again, they are technically DNRs, but you can, as a patient, you can say, hey, I want everything, which is totally different than, I want nothing. Other legal stuff here. So negligence. So there's two types of negligence out there. It's a sad thing to say, and this happens, I think, across all of humanity, but we learn by making mistakes. Mistakes happen in the field. Everyone at some point in their career is going to do a med error or they're going to do something that was it's called simple negligence. It's just basically you brain farted and something went wrong. The person might or might not have been harmed by the process, but ultimately it's a lesson that you learn. Hopefully the person's not harmed permanently. Generally, these usually don't go past your agency. You might get called into the office. They might talk to you about it. You might get some training to help minimize future situations and all that. But those rarely go to court. Now, gross negligence is something entirely different. This is something that you shouldn't have done. You knew you shouldn't have done it, and you did it anyway, and the person was harmed by it. So this is a point where it's something that should never have happened, but because of your ego or your stubbornness or whatever it might be, you decide to do it anyway. Usually, a lot of times, like arrogance. I'm a paramedic. I know everything. Kind of arrogance. It does happen. So if you do go to court, there's 4 elements that they have to prove in a court of law to find you negligent. First, did you have a duty to act? Well, let's say in this case you're on duty. So yes, you had a duty to act, you had a duty to respond, but you breached that duty in some way. And because you breached that duty, the patient was somehow harmed or injured. And they can prove that the breach of duty directly resulted in the injury or harm. If they can prove all 4 of these, you'll be found negligent in a court of law. When you're transporting a patient to the hospital or even at scene as well, you need to give a turnover. Now, in this case, you're at a hospital, there's a physician there and there's a nurse there. You're giving them a turnover, which is basically just usually a very abbreviated version of your radio report. And they say, yes, I got this all stuff. You move the patient from your gurney to their bed. They're now the hospital's issue right there. If you're out in the field and let's say you're a firefighter, EMT, you're at a scene of a traffic collision, you've got 3, 4, 5, 6, 7 patients, you call in ambulances to transport. The ambulance EMT is going to get out. You guys are going to do a face-to-face. And at that point, you're going to give a turnover, a verbal turnover to the transporting EMT. And again, that's a transfer of custody right there. So if you don't transfer the patient to someone at equal or higher training, then that might be construed as abandonment. Assault is threatening someone to do something. Sir, if you don't let me put oxygen in your face, I'm going to do something bad, whatever it might be. So you're threatening them. So assault is threatening someone to do something to them, and battery is actually touching them against their will. So like the guy right here, if he's awake and alert, she would ask permission. Sir, do you mind if I assess your belly? And he says, yes, go ahead. Obviously, that's not battery. If she does it against his will and he says, no, don't touch my belly, she does it anyway, that's battery. Now, if he's unconscious or disoriented, it's implied consent, so it really doesn't apply in that respect. When you are at scene, I mean, we're all human. We all have thoughts. One of the hardest things you're going to have to learn to do, most people anyway, is to filter your thoughts before you speak. So you can think whatever you want when you're at scene, but you shouldn't verbalize them, or especially you shouldn't write them down, because you could be found negligent because of slander, libel, or defamation of character. So again, think what you want to think, because that's just the way humans work, but filter what you have to say. I'm sure a lot of you already have been exposed to the HIPAA law, and this is the Portability Act that they passed about 15, 17 years ago or so. You signed, it gives you access to your personal health care information and all that. When it comes to pre-hospital care providers, we have a legal obligation, a federal obligation, to protect patient confidentiality. So when we have a patient and we have their demographic information and their physical finding information, we can only share it with people that are within the continuity of care. So if you're working with firefighters, you can tell them about it. When you get to the hospital, you can relay it to the nurse or physician who's going to care for the patient, but that's pretty much it. So we have to really limit what we have to say about this. You might encounter a police officer or a sheriff or CHP. They might ask you, what are the patient's injuries? Technically, based on HIPAA, you really aren't supposed to tell them. Now, the patient can tell them themselves, oh, my leg's broken, my back's broken, I don't feel good today. But technically we're really not supposed to relay that to the cop, because they're not really within the continuity of care. You go on these high-profile calls, and I guarantee you're going to get some type of press person there filming the whole thing. They're going to want some information. They're actually very aggressive. They will get in your face and they'll shout at you and trying to raise some kind of response from you. Don't speak to them. You only have to give them your name and badge number, and that's all you have to give them. I usually refer them to a captain or a battalion chief. You talk to the guy in the red or the white helmet over there. With that, and any public, imagine if you're at the scene of some kind of incident at a private residence. You're inside, you're doing something, there's a knock on the door, and the next door neighbor comes over and goes, how's Maud doing? Is she okay? Well, you can't tell them anything. It's a HIPAA violation, unless you turn to the patient and say, this is your next door neighbor, Jill. Would you like to see her? Would you like to talk to her? And then of course the patient can make that their own decision about that. But otherwise, don't say anything to anyone about the patient. EMTALA is another law that's been around for about 25 years now, and basically it primarily was designed to provide medical care for patients in active labor. So this means you're having a child and you get to the hospital, you have no medical insurance, you have no physician, and you show up and they have to render care to you and your child and stabilize you before moving you to another facility. For us, the big thing with this is stabilizing. So if you're working as an EMT, what happens sometimes is a patient will stagger into an emergency room, gunshot wound, or really critical patient. They'll stabilize the patient, and because that hospital he staggered into isn't really designed to deal with that type of injury or illness at that point, they'll call for transport and they'll move this person from that hospital to a more appropriate hospital, like go to a trauma center or a burn center or something like that. So they'll call you in the ambulance and they'll have you transport this person from one hospital to the other hospital. Before you can transport, the patient has to be stabilized. So if you arrive at the hospital and you feel this patient is unstable, their vital signs are unstable, they're close to death, and the hospital is just trying to dump them, then that you can refuse that transport until the patient is stabilized. So again, that's the main thing behind EMTALA. When it comes to scene dynamics, so again, this is that face to face you're seeing here. The guy in the blue shirts giving a face to face to the guy in the helicopter uniform there, and they're doing a turnover. And it's really important that that turnover is pretty concise, pretty full report. That way, the guy in the helicopter suit knows what's going on, knows what's been done for the patient, and can then continue care, and the person can get the right care for the patient. There are some weird situations you might encounter when it comes to high risk calls. This usually involves drunks, drugs, psych patients. So you have a patient who's intoxicated, they're under influence of drugs or alcohol, have some kind of psychiatric meltdown, and these patients, if you were in the back of the ambulance with that patient, that patient might start talking about how they're going to report that you tried to touch them inappropriately, or you tried to rape them, or whatever it might be. If you have a situation where you have a person who's especially a female patient who's intoxicated, or a female psych patient, and you're a male EMT, and you really should bring a witness with you. I've been on a number of these calls, and I always bring either a police officer, a firefighter, a family member, somebody to come with me, because I know this is going to turn bad if I'm by myself. I've made the mistake a couple of times. I've been caught out by these people, and I've had these patients tell me that they are going to tell the doctor at the hospital that I raped them, and sure enough, this one person did, and law enforcement got involved. But luckily for me, and luckily for you, I don't know if you guys know this or not, but all the AEDs and the ECG monitors, the monitors the medics have, or the little AED that you guys have, they all have like data sticks inside that record all the sounds like within about a 30-foot radius. So whatever the person's saying, whatever you're saying, all the sounds within the ambulance, it's going to get picked up. So if you think this person's going to go off and you think that there's a potential for this, all I have to do is just turn on the AED. You don't have to attach the pads. Just basically turn the thing on and let it run. And it's a legal document. It can only be opened by your medical director, and it can be subpoenaed in a court of law, the transcript anyway, from the data stick inside the device. So if you have this person telling you that they're going to, you raped me and you touched me inappropriately and I'm going to get you fired and you're going to blah, 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 turn on your AED and let it run, because it might save your career. Now, when it comes to law enforcement, you can call them as necessary. Sometimes that helps with scene safety. Sometimes it makes it less safe. It really depends on the officer themselves. I've noticed that a lot of the older officers that have been around a long time usually are a lot calmer. They provide a lot more control over the scene. The younger officers, they're in there gunning for something, and they have a tendency to cause a lot of conflict. They argue with the patients, and they argue with us, and it's unnecessary conflict. Once you are transporting to the hospital, it's good to know which hospital you're going to. Go figure. Try to take the quickest, safest possible route to the hospital. So it might not be the shortest, but for instance, if you have a person with a broken back or a broken pelvis or broken femur, they're not going to like the bumps in the road, I got to tell you. So maybe whoever's driving might know a smoother road to take to the hospital. It might take you a mile or two out of the way, but it's going to be probably quicker because it's smoother. You'll be able to drive faster and get to the hospital probably around the same time, but it's a smoother road and the person's a little, obviously less uncomfortable. So signs of death. So there's what's called presumptive signs of death. This is a person who looks alive, but they're dead. So you can't feel a pulse. You don't feel any breathing. They're completely unresponsive. There's just basically they are completely unconscious. Now, because this person has no pulse, obviously you're going to start compressions and ventilations. There's no obvious signs of death with this patient. Unless there's a DNR there or some kind of pulse or other extenuating circumstances, you're just going to start compressions and go from there. On the other hand, obvious signs of death. Now, if the head's missing, it's kind of a slam dunk, decapitation, the head comes off. Rigor mortis is stiffening of the muscles. We have these two substances in our body, actin and myosin, and they're released and they allow us to contract and relax our muscles. So when you flex your muscles and you extend your muscles, that's actin and myosin going to work. When you do die over a period of time, hours, days, whatever it might be, the actin and myosin stop being produced and your muscles lock. And so rigor is something common. Within hours after your death, you go into some form of rigor. What's nice about rigor, for us anyway, is rigor usually starts in the very, very finest skeletal muscles. So this is fingers and toes and the jaw. Now think about it this way. You go on a call, some guy's laying in bed, and the first thing you're going to do is, sir, you okay? No response. Check pulse, check breathing. No pulse, no breathing. You're going to start compressions, and then you're going to try to open the airway to insert some type of adjunct. Well, you try to open the mouth, and you can't open the mouth. That's rigor. So that just means basically this person is beyond help at that point. But rigor could be the whole body. It could be the jaw. It could be the fingers. But obvious sign of death. Decomposition. Think about it this way. So I don't know if you guys ever been to Sprouts, the market Sprouts, and it's like 9:30 at night. And you get that last barbecue chicken that's been under the heating lamp for the last 8 hours, and that heat has denatured all the proteins, and that chicken is like really falling apart because all the proteins have been broken down. So what happens with the human body over time? It starts to decompose. It gets all loosey-goosey, starts literally falling apart at the joints. It smells really bad too, I got to tell you. So obviously this would be like, okay, they're done. You'll see in this picture, you'll notice, it's kind of hard to see, but you'll notice that his arm and his leg is really purplish and the rest of his body is kind of white. That's the blood that's pulled down to gravity, and because his heart's no longer pumping, it just kind of pulls down towards the floor. This is called dependent lividity. If he were lying on his back in bed, all that purple color or discoloration would be on his back and the back of his legs. If he was face down, you guys get the idea. If you find them and their heart's over there and their brain's over there and they have no pulse, well, obviously that's a kind of a slam dunk. And with incineration, person is grossly burned and they have no pulse. Again, you consider that to be an obvious sign of death. Last but not least with this is there are certain special reporting situations. So various types of abuse. So this would be child abuse, elder abuse, neglect. So abuse is physical, something like burning the person, cigarette burns, beatings, whippings, things like that. Neglect is if someone isn't cared for. They're not given their medications, they're not fed, those kinds of things. When it comes to crime, really, we need to report felony crimes, and this is primarily assaults. gunshot wounds, stabbings, beating, people getting beat up, things like that, well, for whatever the reason. Attempted suicides, of course, need to be documented and reported. And if you encounter someone who lives by themselves and they're in a state of what's called failure to thrive, so this person is unable to care for themselves, even though they're oriented and they're fully, with it and all that, they just can't feed themselves. They can't care for themselves. Their house is filthy. They're unable to function. That's also needs to be reported to the county, and the person needs to be, taken against their will, unfortunately, to the hospital and maybe put into like another home where they can be cared for. I think we're done.